There's a very interesting and popular understanding when it comes to shoplifting as to whether or not the would-be shoplifter, defendant, thief has to leave the shop before it becomes theft and before the security guards can tackle the would-be offender and so on. So that's what I'm going to address in this video. So welcome back. I'm the Black Belt Barrister, helping you to understand law. In this video, talking about shoplifting. I've done a number of polls on this just recently, which is really interesting because I will show the figures on screen now if there's sufficient votes in, just to show what people generally think as to whether you have to leave the shop first before it becomes shoplifting, or whether it becomes shoplifting beforehand. But before I get to the real answer, I'm going to explain why that is a common understanding. Whether or not it's the law or not, you'll find out at the end, but why it's a common understanding. And that is because security guards are generally taught, as far as I understand it, that the defendant or would-be defendant must leave the store or attempt to leave the store or go beyond the last point of payment before they can detain them for suspicion of shoplifting. And the reason I believe this to be is that it's much easier to prove the intent on the part of the defendant to steal the goods once they've left the final point of payment. Because unless it's a pure accident, and that happens from time to time, if they have goods on them and they've left the store and they haven't paid for them, clearly it's so much easier to prove that they intended to steal them because they've left the final point of payment without paying for them. And more importantly, the security guards are going to want to detain the individual until the police arrive under a citizen's arrest. Now, there is no formal legally defined citizen's arrest in those terms, but the Act simply provides that any person may arrest someone who has committed or in the act of committing, to a reasonable belief, an indictable offence. So coming back to the basics, theft is an indictable offence in that it's an either way offence. Low-value shoplifting, many people may have heard there is a slight ambiguity with it in that shoplifting under £200 is considered low-value shoplifting and is supposed to be heard summarily. However, it doesn't deprive the defendant, A, of the time restrictions that are applied in a normal case, and B, the option to elect a Crown Court trial, because ultimately it is still an offence of dishonesty that can have serious repercussions to that person's life. So if they so elect, even on low-value shoplifting, they can have their trial in the Crown Court. It just can't be sent to the Crown Court if it's a low-value shoplifting. Unless, of course, it is materially attached to some other kind of offence which is going to be going to the Crown Court, in which case, if one goes to the Crown Court and they are linked, they're all going to the Crown Court. So unless it's a completely separate offence, it's going to the Crown Court with the other offence. So breaking this down even further, shoplifting is just theft by another name. It's theft from a store, theft from a shop. It's simply theft, which has 5 elements. It's the dishonest appropriation of property belonging to another with the intent of permanently depriving that person of it. Now, many people will argue, and have argued in the comment section, that there is no way of proving the dishonest intent if they haven't left the store. But that's not quite true. In almost every jurisdiction, this is simply a myth. You do not need to have had the defendant leave the store or even attempt to leave the store for it to become theft. The act of theft itself is defined by those elements. So if a person has dishonestly appropriated property belonging to another with the intent to permanently deprive them of it, those all might have happened whilst they are still in the store. And I'll give you an example, which I left in the comments somewhere, that you should be fairly easily convinced by. Picture a normal supermarket shopping centre. You've got the defendant pushing a trolley which has got in it a few items of fruit, a loaf of bread, 1 or 2 other ordinary items, but they're wearing a large jacket which is kind of bulging and got some secret compartments inside it. The CCTV operator has been watching this individual. They've spent a long time around the razor blade area because those are typically fairly expensive and easy to sell down your average public house. And this would-be shoplifter has been waiting there whilst there are crowds of people there looking out for cameras as they are doing so. Next, they moved on to the aftershave or perfume aisle. And the same thing again. They've spent a huge amount of time around that area, waited for a crowd of people, looking out for the cameras once again. The CCTV operator has become very suspicious. He or she has radioed down to the store floor security officer, who may well be in plain clothes and is trying to keep a lookout around the store, has spotted this would-be shoplifter, indeed taking these items off the shelf whilst looking around, slipping them into an inside pocket, zipping it up, and hoping that no one sees it. Now, this security officer, growing increasingly suspicious of this would-be shoplifter, with what he or she suspects as to being lots of different items of razor blades and perfumes stuffed inside this pocket, still pushing around the trolley with 2 or 3 pieces of fruit and a loaf of bread and a newspaper, the security guard then radios for a colleague or two to come and help detain this shoplifter for the purposes of a search, voluntarily, because they can't force you to volunteer to a search, or to wait for the police to arrive. The reason being, if the security officer forms the reasonable belief that they have committed or are in the process of committing this offence, they can detain them by way of a citizen's arrest, as it's commonly referred to, if it's not practicable for a police officer to make the arrest, to prevent them from absconding, and to wait for the police to arrive. Sure enough, the police come and arrive, and then the police ask them to volunteer to a search. They say, "No, I'm not volunteering to a search." The police say, "Well, on the basis of what the security officers have said, we have the reasonable belief that you have committed an offence of shoplifting, so we are going to detain you for the purposes of a search." Sure enough, and lo and behold, they search the person, and they've got 4 or 5 concealed compartments which have been deliberately fabricated into this coat, in which they have stuffed razor blades and perfumes and aftershave to the value of, let's say, £150. This comes within the low-value shoplifting, but shoplifting and theft nonetheless. Now, remember I said that shoplifting is just theft by another name. It's just categorised because it's a lower value and the courts wanted to make it easier and quicker to deal with, although the defendant still has the option to elect Crown Court trial. Therefore, it is still going to be judged either by a magistrate or by a jury on the same elements of theft, which is, as I said, the dishonest appropriation of property belonging to another with the intention to permanently deprive that person of it. Now, these are relatively easy to prove in this scenario when they've got a coat stuffed full of these things which are concealed. So remember, the test for dishonesty is an objective one, since Ivy and Genting Casinos in the Supreme Court decision. Thereby, the objective test: would a reasonable and honest person believe that this action was dishonest? Was it a dishonest appropriation? They've certainly appropriated the goods because they've stuffed them inside a pocket. Was it dishonest? Well, if a reasonable, honest person would believe that that is dishonest to conceal them inside the coat, then yes, it was dishonest. Is it property? Yes. Does it belong to another? Yes, because they haven't paid for it yet. The intention to permanently deprive the person of it. Now again, the intention to deprive is relatively easy to prove here, because they have a trolley into which they've placed things that they are presumably intending to pay for, or at least pretend to pay for. But as to the items concealed in the coat, it is much more likely that a magistrate, or perhaps even a jury, are going to conclude that they were concealed there with the intent not to pay for them and to permanently deprive the shop of these items. Now, of course, you might get a sympathetic jury that decides against convicting the individual just on their own decision, regardless of what the law might say. But coming back to the point, it is simply a myth that the would-be shoplifter must leave the store before it can become theft. Leaving the store is simply not one of the elements of theft or shoplifting within the legislation. Now, as I said, indeed it is much more common practice for the security officers to wait for the person to leave the store first, but given the situation where there's a mountain of CCTV evidence and the officer watching the defendant conceal them inside a coat in hidden compartments, it is much more likely that either a magistrate or a jury are going to convict this individual without ever having left the shop. I hope you found that an interesting trivia. Please do give the video a like and subscribe to the channel, and as always, thank you for watching.